Hello and welcome to JHK Today with Rick Jones. Today's episode we're going to talk about unfair dismissals. A lot of employees, particularly in these COVID-19 times, are really concerned about their workplace safety, their employment safety, and whether or not going through to September they will have a job, and also post-September. Conversely, a lot of employers are concerned because at the moment they're being kept alive by JobKeeper. JobKeeper is paying those employees. So there is a lot of inquiry coming through to us about what might or might not occur with various employees. So if somebody's dismissed, as an employer, you have a number of things to look at. If you wish to dismiss your employee or a series of employees because you do not have sufficient work for them, you must apply these types of things to those employees. So you must say, is my action fair? Is it harsh? Is it reasonable? If it's harsh and you haven't taken the appropriate steps, then your employee might be able to bring an application with the Fair Work Commission. For an employee to bring that application, it has to fit within a number of criteria. An eligible employee's criteria for bringing an application for an unfair dismissal claim includes the application has got to be brought within 21 days of the dismissal taking effect. Secondly, the employee must be working under the National Employment System. Thirdly, the employee cannot be paid more than $148,000 per annum. And then also there are some other criteria that take place, and that is the employee must have worked for at least the minimum period. For an employer who employs more than 15 people, that means the eligibility criteria is working for more than 6 months. If it's less than 15, the eligibility criteria is the employee must have worked for more than 12 months. So we look at these sort of circumstances for an unfair dismissal claim. If the employee can't meet those criteria, then the application has no merit and it won't be heard. If they do fit those criteria, then it will go to the Fair Work Commission, and the Commission will then hold a conciliation conference between the employer and the employee to see whether or not some sort of fair result can come out of it. The other aspect of an unfair dismissal can be that an employee has been terminated because of discrimination or some other unfair or unlawful grounds. In those sorts of circumstances, that's when the general protections provisions of the Fair Work Act come into play. And in those circumstances, there are a lot of employees who justly bring their application because, for example, they may have taken a day off work and been sacked unfairly. They may have been sacked because of race or religion or some other unlawful ground. These people have all got a claim, and you as an employer have to be exceptionally careful. So in these sorts of circumstances, JHK Legal can assist both employers and employees. If you have an issue here or if you have any concerns, feel free to contact us. Thanks.